Auburn, California. I'm going to give you a brief overview of the options in bankruptcy that are available to most middle-class families and small businesses. Generally speaking, the options are the Chapter 7 liquidation, the Chapter 13 wage earner or debt repayment plan, and rarely a Chapter 11 business reorganization. Under Chapter 7, which we call the liquidation bankruptcy, the legal theory is that the bankruptcy trustee takes those assets you own which are not exempt from taking, and by the way, there is a list of things that are exempt from taking. He sells those assets and distributes that money to your creditors, and you are then discharged from the rest of your unsecured debt. With regard to Chapter 7, the first question that comes up then is, well, what assets are on the list of things that are exempt? What do I get to keep? Well, the reality of Chapter 7 is quite a bit different from the theory, because most people, by the time they get to see me, the bankruptcy lawyer, are so broke that almost everything, or sometimes and often everything that they have left, is exempt from being taken. The legal theory being, we don't leave you homeless and we don't take the shirt off your back. We give you a chance to make a fresh start. So the first thing you want to know is what items are exempt. Well, we'll cover that in a different session so that we can get through the brief overview. You also need to make a quick distinction between secured creditors and unsecured creditors, and we'll also cover that in a different session. The second type of bankruptcy is a Chapter 13, often called the wage earner plan. I like to call it the consumer debt repayment plan. And in a Chapter 13, you don't really get discharged from your unsecured debt, at least not until after you have made and completed a debt repayment plan and you have made payments to a Chapter 13 trustee for a period of 3 to 5 years, repaying at least a portion of your unsecured debt. You must have a steady source of income in order to qualify for a Chapter 13, and you must meet certain debt limit requirements. That is, your unsecured debt cannot be above a certain dollar amount, and your secured debt cannot be above a certain dollar amount. I personally do not like Chapter 13s. There is a very high failure rate in the Chapter 13 filings. All the lawyers that are yelling and shouting that Chapter 13 is going to solve all your problems, advertising this, my problem with them is that they don't tell you that only about 35% of the debtors who get a plan approved actually succeed in completing their repayment plan over the period of 3 to 5 years and get their debt discharged. Everyone else gets into a Chapter 13, struggles and suffers and makes payments for a year or two, then misses a couple of payments and gets dismissed from bankruptcy or converted into a Chapter 7 anyway. And the only difference between filing a Chapter 7 now and filing it later is that you struggled and you suffered and you made those payments for months. There are, however, certain times when a Chapter 13 is the only way or the best way to go. One of those times is when you have a lot of high-value assets that you don't want a bankruptcy trustee in a Chapter 7 to take and sell. If you have high-value assets that are not exempt, you get to keep all your assets in a Chapter 13 because you are making repayment. So a Chapter 13 might be right for you if you have a lot of assets you want to hold on to. Another time is when the tax man is after you. There are some exceptions to this, but as a general rule, taxes are not dischargeable in bankruptcy. So filing a Chapter 7 might get you a very brief period of relief from the tax man, but then he's going to keep coming right after you. In a Chapter 13, however, if you're making small payments to the IRS along with your other unsecured creditors, you can at least hold the IRS off for a period of 3 to 5 years, hopefully get your other debt taken care of, and then figure out how you're going to take care of your back taxes. So if you have tax problems, a Chapter 13 might be the way for you to go. Also, if you have problems with your house and you're trying to save your house but you're in arrears on the payments, in a Chapter 7 you've got to be able to bring your payments current in order to keep your house. But in a Chapter 13 you can take your payments that you've missed and tack them onto the back end of the payment plan and just make your payments, keep your payments current from here forward. There is also a possibility of doing what's called a lien strip-off in a Chapter 13, whereby if the value of your house has gone down so much that there's no longer any equity or value in the house available to secure the amount of your second mortgage, you may be actually able to strip off the second mortgage as a lien on your house, lump it in with your other unsecured debt, and make a payment of a small part of it over 3 to 5 years and reduce the amount of your house payment. So sometimes 13 is a good way to go. I personally don't like them. They were lobbied into law by the credit card companies, and I think if you can avoid a 13, you should do so. The final option for some businesses is a Chapter 11 business reorganization. Now, a lot of small and mid-sized businesses want to get into a Chapter 11, but over the years they have finally polished up the Chapter 11 process so that it serves only the businesses that it was originally intended to serve, that is, very large businesses with very large numbers of employees. The whole idea of the Chapter 11 was to give large businesses a chance to freeze the attacks of creditors for a brief period of time, giving them time to maybe reorganize their financial problems and thereby save all those jobs, hopefully to save all those jobs. So Chapter 11 is very complicated nowadays, it's very expensive, and I generally don't recommend it for small to mid-sized businesses. It usually does not work for them. And I would say that one of the major failings of the Congress and the legislature is that they do not have a workable vehicle in the bankruptcy court for allowing small and medium-sized businesses to have a brief timeout period, hold off the attacks of their creditors for a short period to give them a chance to reorganize and save all the businesses that are involved in small and mid-sized businesses, which we know actually generate more jobs than the big corporations. If you have other questions and you're in the Northern California area, give me a call. This is Bob Litchfield. My number is 530-889-2777. If you're in financial trouble, God bless you and good luck.